Hey, good afternoon. I'm going to call the meeting to order, and I would remind everyone that only committee members and Attorney Del Campo should have their cameras on, and that if we have participants who need to address the committee, at that time it would be appropriate to engage their camera. And please have your microphone remain on mute during the meeting if you're not speaking. So Attorney Del Campo, can you please take the roll call?
Yes, Your Honor. Your Honor is here. Judge Aaron.
You think you're on mute?
I can see you, Your Honor. He can't hear you.
I can't hear you, Judge Aaron, either.
Maybe sign off and sign on again.
I'll continue. Judge Armada.
Here.
Judge Chaplin.
Here.
Judge Green.
Here.
Judge Maturowski. I believe she's on trial. Judge McLaughlin.
Here.
Judge Pearson.
Here.
Judge Stewart.
Here.
You have a quorum, Your Honor. I'll go back to Judge Aaron. Judge Aaron?
Can you hear me now?
Yes, thank you.
Here.
Thank you. You're all set, Your Honor.
Okay, I had my computer on mute. That's why I wasn't able to hear you or anyone else. All right. So we have a quorum. You've taken the roll call. The first item on the agenda then is the approval of the minutes from the January 13, 2025 meeting. Is there a motion to approve the minutes?
So moved, Judge Pearson.
Thank you. Is there a second?
Second, Judge Armada.
Okay. Are there any additions or changes to the minutes? Hearing none. All in favor of these minutes, please raise your hand or say aye. Everyone looks like they're in favor. Thank you. Any opposed? Don't see any. And is there anyone who is abstaining from these minutes? And if so, please state your name.
Judge Chaplin, I was not present, so I'm abstaining.
All right. Then the minutes are approved without changes and the notation that Judge Chaplin is abstaining. So moving on to our next agenda item, it's item 2024-008. It's the proposal to amend the practice book section 2562 (B)(1) to include board certified behavioral analysis. And Attorney Del Campo, can you summarize the history of this item and where we are?
Yes, Your Honor. This was on last month, and the committee had discussed it. I had asked to take it back just to finalize the language so that it would be consistent with the way the practice book standards of style have been established. I did that. In your package, you have a revised proposal that I submitted. It was not intended to change anything substantively. It was just intended to organize it a little bit differently in the kind of sort of outline form. Basically takes that new provision applicable to mental health professionals and separates it out as one of the three categories of individuals that may be eligible to become a GAL. Judge Diana did ask to see that this morning. I sent that to him. He did get back to me, and he did approve the language, the revised language.
Right, and that's the language that's found in our record at 2024-008G. Is that correct?
Yes, Your Honor.
First, is there anyone here to address the committee on this matter?
I believe that would be me, Christina Torres.
Okay, hi, Ms. Torres. You are the proponent of this. So what would you like to tell us today?
I'm not exactly sure. Does this mean that we would move forward and it's approved?
What the committee now has is language that's been prepared that includes your proposal. Judge Diana, who's the chief family judge, has looked at it and he agrees with the language. And I know that you're here and we've heard from you previously. So if there's nothing other to add, then I'll ask the committee if they'd like to discuss it or consider it further and mark it over, or if they'd like to go forward with a vote today. Okay, so thank you.
Thank you.
All right. With that, any discussion from our committee members? Hearing none. Oh, go ahead.
Well, Judge Machorowski isn't here. Last time her comments were that she wanted, she approved this, the language and proposal to try and give more mental health professionals as guardians. And I think it's important to remember that. And I think, we could put it to a vote today.
Right. I agree. I think it's ready for a vote. I want to thank Attorney Del Campo and his team for proposing this, because I do think it is slightly different, but it is consistent with the way the courts decide to designate someone as a guardian ad litem. So if there's no other comments or questions from the committee members, I guess we generally have you vote as to whether or not we should move this proposed language as is, or any changes. And I'll just ask, first of all, if there are no other questions or comments, do you want to approve sending this proposal as prepared?
I do have one question.
Okay.
I'm sorry. I remember in one of the previous meetings, it was questioned if it would just serve underneath family law, because I understand there's other divisions. Would that just stay underneath family law, or do you think it would carry over in the other divisions as well?
I think right now, as proposed, it says any family matter.
Okay.
And so I'll ask Attorney Del Campo, this is the family section, correct? And I see Attorney.
Yes, Your Honor. Yes, it is.
Okay. So to answer your question, Ms. Torres, this is the proposal to the family matters, okay?
Okay, thank you.
You're welcome. All right. If there are no other questions or comments from the committee, I guess we can make a motion to approve sending this to the public hearing.
So moved.
And is there a second?
A second. To Jared.
Okay. Thank you. It's been moved and seconded. Any other discussion? Seeing none, all in favor, raise your hand or say aye. Right, and any opposed? See none. So I think it passed unanimously. And again, Ms. Torres, I know you're still on the screen, but thank you for bringing this to our attention and giving us the opportunity to present it to the judges of the Superior Court. Thank you very much.
Thank you, guys.
All right, the next matter is 2024-09, the review of the proprietary party having ex parte communications with a disclosed expert witness of an opposing party. And this was generated out of a Supreme Court decision, Epright versus Liberty Mutual. And Attorney Del Campo, can you let us know the history and where we are today with this?
Yes, Your Honor. This was brought forth by Justice McDonald originally. It was given out to Judges Diana Bellis, the CBA, CTLA, CDLA. It came back last month. He decided to send it also to Judge Wynne O'Dowd. She has now given you her comments. They're in the package. Those are the most recent, and that's a new material in the package at this point. And you're ready to discuss it at this point.
Is there anyone here from the public that wishes to be heard on this? Hearing none. Would any of the committee members like to discuss this?
I would.
Go ahead, Judge Aaron.
Just briefly, I just want to reiterate, I read Attorney Nguyen's comments, and I'm just not exactly sure in terms of languaging this, whether we would want the practice book section 34A-21 to be exempted from 13-4, because I know that typically in juvenile court, the court orders evaluations, but the parties are also aware of who that expert is. And 34A-21 speaks very specifically as to what communications are appropriate and when by counsel for the parties. So I just think it needs to be clear that 34A-21 should supersede, at least for juvenile cases, any changes to 13-4.
I agree that that has to be included in any language that we choose to send to the public hearing, because it is different in juvenile. So thank you. Any other of the committee members wish to be heard or discuss this?
Judge Stewart, unless I'm missing something, there isn't even a written proposal yet. And the comments were pretty heavy and all over the place, as they should be. I mean, I myself have conflicting views on this. I personally think we need and I'm not volunteering for this because my term ends this spring and I can see there's no way this is getting done in time for the March meeting for us to vote on. But I think a small task force needs to be created to draft some language here and to incorporate all of the comments, including the comments just made by Judge Aaron.
I agree. That's why I'm trying to see who is discussing this, and I respect that you're going off the committee and not volunteering for this, but other members, I think, obviously I'd like Judge Aaron, at least for you to do the part with the juvenile section in the committee. Any of our other judges wish to not volunteer, but at least look over this. It's a lot of material, and it is there's no unanimous consensus on how to do this. So if no one wants to volunteer, we'll draft you later by email and see. And we'll also watch when your terms are ending. With respect to it, I know that we did get comments from the CBA, CTLA, CDLA. Is anyone on those committees interested in commenting at this time?
Good afternoon, Your Honors. I'm Carolina Dowd. I am here on behalf of CTLA, and I think just to voice or reiterate what was submitted in our written comments, we agree that this is an important issue and that people from the various groups may come from it from a different perspective. And one of the things that we had suggested might be a good procedure for us to do in terms of the language that's ultimately submitted is to have a working group which includes all of the players. It's something I've been involved in the past. And again, I just wanted to kind of voice that I think at least CTLA would be very happy to be involved in the drafting. And I think it would be helpful to have the other players involved in that type of process. And I'm happy to answer any questions.
Does anyone have questions for Attorney Dowd? Right. Oh, Judge Armada, go ahead.
So to the extent that you're coming at it from the CTLA, which tends to be more civil, the CBA is a partner, and they've got sections on juvenile law and family law who may have interest in this in terms of the ex parte communication. So it may be good to reach not only to the CBA general, but the individual sections that could be affected by this.
Okay. Any other questions, comments? Hearing none. I think what I will do, if it's okay with the committee, is I'll talk to Attorney Del Campo after the meeting, see what we can do to put together a working group. So you might be recruited as opposed to volunteering, and we will get this working. Attorney Del Campo, can we just mark this as off, and then we can see where we are? Because again, I think Judge Stewart brought up a good point. We have our March meeting and then we go to our public hearing in May. So I'm not sure that we'll have the time to get this through before the end of this committee year.
Sure, Your Honor.
Okay. So we'll move on to the next proposal, which is 2024-13, a proposal to amend discovery rules in summary process matters. And Attorney Del Campo, again, I'm going to ask you to give us a history and where we are with this now.
Okay, this was on the agenda last month. It was tabled to this month and referred to the Judicial Branch Access to Justice Commission and the CBA. The CBA has no comment. That's their comment at this point. The Judicial Branch Access to Justice Commission does not meet until April. Judge Bright, who's the chair of that commission, I did contact him. He wanted to get this committee some comments. So he did submit comments from himself and Judge Spader, who is on the Access to Justice Commission, and I guess does a lot of summary process work. And those comments are in your package for this month. You don't actually have the Access to Justice Commission's comments because again, they won't meet till next month, and till April, and that's too late for this committee. So that's the status of it at this point. You have received comments from Judge Bellis a couple times, and from the civil judges through her, Attorney Lowry, the Connecticut Advisory Council on Housing Matters, also submitted comments. And I believe Attorney Shea is here and may have some comments.
All right. Yes, I was going to ask if there was anyone here from the public who would like to be heard on this proposal.
Thank you, Justice Alexander. Giovanna Shea from Greater Hartford Legal Aid, one of the 6 legal services organizations supporting this proposal and a right to counsel provider. Chief Judge Bright, I should say, in his comment did say, would this committee like this matter to be placed on the Access to Justice Commission agenda in April? And at this time, obviously we don't think there is any kind of consensus. This is not ready to go to public hearing. It's not going to go before the judges in June. We would ask that it be on the Access to Justice Commission agenda for April. Obviously, Judge Spader is very experienced in housing matters, but I do note, concerns have been expressed regarding self-represented landlords, and the most recent, the 2023 Right to Counsel report showed that currently 71% of summary process matters are a tenant who's unrepresented and a landlord who is represented, and only 1.7% of such matters involved an unrepresented landlord and a represented tenant. So I think it would be helpful for the Access to Justice Commission and all of the stakeholders on that to discuss this matter. And prior to receiving the comment from Chief Judge Bright and Judge Spader, We had also asked this committee to refer back to the chief administrative judge a proposed standing order for the portion that would really not require a rules change, with the benefit of some comments from CBA members of the House of Delegates, and I would defer to the committee on whether it thinks that would be appropriate. Thank you.
All right, Attorney Del Campo, I would ask you, because I don't think Judge Bright is on our meeting today, to please let him know that Attorney Shea does want this on the Access to Justice Commission schedule and hearing in April. Committee members, regarding the standing order, again, this proposal has had a lot of different input, and it's been, varied in what should happen. Would anyone like to discuss the standing orders? We could obviously forward it, I would guess, to the Chief Court Administrator's office and see if they had any input on that. I think Judge Facito might be on today. I'm not sure if Judge Pizzuto is, but any other ideas about what we should do as far as this proposal goes? I don't see anyone. Oh, Judge Armada, please.
So I think we're getting a sense that we're going to mark it off of this year, put it
Yes.
on for next year, get information from the Access to Justice Commission. But my understanding is the standing trial management orders, or the standing orders out of each division, are set by the chief administrative judge of that division.
Okay.
So to the extent that there is a request to change the standing orders, I think we just refer it to the chief administrative judge and see if they want to change things.
All right, we can certainly do that. I do think I'd probably want to loop in the chief trial court administrators, just so they're aware of any discussion that's going on, and that would be in the civil court for the housing matters. Anyone else wish to be heard? And again, I'm not exactly sure of the language, but it's marked over, off, until we get further information.
Your Honor, can I just clarify, you want this to go to Judge Bright for the Access to Justice Commission? Do you also want it to go to Judges Pizzuto and Facito and Judge Bellis?
Yes.
Okay,
Thank you so much.
thank you.
You're very welcome. Thank you. Our next matter on the agenda is 2024-16, which is a proposal for new rule concerning gender inclusive and sensitive terminology. And it is also, I believe, related to a later matter on our agenda, which is 2024-20, which was from Attorney Steele about the names and pronouns for attorneys. We did have a subcommittee, and with respect to it, thank you, Judge Chaplin and Judge Pearson and Judge Green. Were you the third? Doing it by memory. Okay. Which of the three of you would like to go first or represent what you did in the subcommittee? Because I think that would be very helpful. Thank you. Go ahead, Judge Pearson.
Thank you, Justice Alexander. So the subcommittee met, has had several remote meetings, and this is language that we worked on and came up with. I will just point out a few things about the proposal, which is can be found at subsection D of item 2024-16. We talked about the possibility of doing something like what the Michigan Supreme Court did. If you recall, the Michigan Supreme Court was saying that parties and litigants, attorneys should bring to the court's attention preferred salutations and pronouns by means of using the caption in a particular case. And it was brought to we were thinking, Judges Chaplin and Green thought that's not an ideal way to bring it to the court's attention insofar as, for example, in criminal cases, there really aren't, when you're charged by information, there really isn't a great opportunity for a defendant to bring it to the court's attention by way of sticking it in a caption. So we thought the best way to do it would be to bring it to the court's attention and all parties involved by having it noted in the appearance form that is filed by defendant in a particular case. And so that is how we've chosen to proceed, is by amending a proposed, by submitting a proposed amendment to the appearance form rules, which is 3-1 and 3-3. In putting forth proposals to amend those rules, which appear, and they are identical, the proposed subsection B to 3-1 and the proposed subsection C to 3-3 are identical. We modified some of the language of the Michigan court rule, and I think we made it a little softer. Our purpose and our point is to indicate that it's the policy of the branch to have judges respect people's pronoun and salutation preferences. But what we also wanted to do is to make sure that there would be no penalties or violation of any rule for inadvertent or mistaken misgendering of people, so that it's not sort of a punitive sledgehammer, as it were, but just a statement of our policy that we want judges to honor people's preferences when it comes to pronouns and salutations, but not to render it overly punitive. And I think that that's reflected in the commentary to each of these subsections. So, with that, that's what we have done so far, and we were hoping to strike a good balance in that regard, and hopefully we've succeeded at least somewhat.
You did an excellent job. Thank you, Judge Pearson, too, for explaining it to us. Judge Green or Judge Chaplin, do you have anything to add to your colleagues' comments? No? Okay. Is there anyone on the committee who would like to ask this subcommittee questions? I don't see any hands raised. With respect to this, I know that originally we got comments from Troy Brown, who is our DEI director. And I don't know if Troy has received this yet, Attorney Del Campo. Has he been able to review it?
He was not sent it directly. I know he's on the call right now, so if he wants to come in and let us know, I'm not sure what he had before him, if anything.
Troy, are you out there? I only see parts of screens. Generally, I have to have.
Good afternoon, Your Honor.
Thank you.
Yeah, thank you, Attorney Del Campo. No, I have not seen it. So the first I'm hearing of it is right now. If I could take a look at it, I would appreciate it. Just to review it.
Yep. I think that would be absolutely appropriate. Is there anyone else besides Troy that should receive this, just to look at it and make sure there's no further suggestions or amendments?
If I may, Justice Alexander, I think the LGBT section of the CBA,
okay.
I know that they had somebody on a few times ago when we were first addressing this particular item, and they seem to have an interest in it. I don't know if there's anybody on today. I don't think there is from the CBA.
Am actually, Your Honor. Yes.
Oh, okay. I'm sorry. Hi. I didn't see you there.
No. Thank you for speaking up. Yes, I'm here as well.
And did you have a chance to look at it?
I haven't seen the language proposed. We had sent proposed language around sections throughout the CBA and actually got approval from the topic for the language that we have. I imagine we've got approval for, the language that you all have proposed as well from the Legislative and Policy Review Committee of the bar. So that came down a few weeks ago in preparation of this. So we got a unanimous approval from that. But if I would love to take a look at it if your honors don't mind.
Of course.
No, that's why I'm soliciting this, because again, it just came in as new material. I appreciate everyone who's participating so that we get this language right and that we can hopefully get it to our public hearing. So Attorney Del Campo, I'm going to ask that you send it directly to Mr. Brown, to Attorney Cutler, so that she can, and you would send it back to the CBA for them to look at as well.
Absolutely. Yep.
Any other organizations or individuals who would need to receive this? Attorney Del Campo, again, in my freshman year, I'm not sure who I'm supposed to send this to, but I'm willing to share with anyone who needs to look at it.
I think that would be it, Your Honor. And do you want me to put it back on for next month?
Why don't we put it back on for, that would be on March 17th. And I think that should give us, if there's some reason, some glitch that we can't get it done, we can always, I guess, add it on to the May meeting if we needed to, correct?
Yes, Your Honor.
But let's try for March 17th. I would rather have it more wrapped up and voted if we can.
Okay.
Any other individuals or comments from our committee? Right, so that will move to March 17th. Thank you both.
Thank you.
Our next item on the agenda is 2024-17, which is the proposal to amend the practice book sections 316 and 321 concerning certified legal interns. And that was proposed, I think, by Attorney Carl Cicchetti of the Supreme Court Clerk's Office. Dean Nelson did respond, and she agreed, although she had one slight modification to, I think, include the word "and" in one of our proposed language. Attorney Del Campo, did we send it out to the other law school deans?
Yes, Your Honor. We sent it to Yale, UConn, Quinnipiac, and Winnick. We also sent it to Chief Disciplinary Counsel and Statewide Bar Council. I think Chief Disciplinary Counsel and Statewide Bar Council are on the call. I don't have comments from them at this point, unless I missed them. But those are the entities or persons to whom we sent it.
Okay. Yes, Judge Stewart, I see you raising your hand.
One of the commenters proposed, and I 100% agree, that the best way to address this is to just get rid of section 3-21 in its entirety, and just have the revised version of 316. Indeed, I think if we left 321 as revised here, it implies that if you're from an out-of-state school, if you just file with the clerk the letter from the dean of your school, that's enough to get you out of all the requirements in 316, some of which, having a lawyer with you, seem like very good ideas. So I just think the best way to address this is to eliminate what was subsection 5 from 316 and get rid of 321 altogether, in which case I would then be in favor.
Sorry, I'm on off. Any other committee members want to discuss this? That's a very good proposal.
Anyone here?
Yep.
My only question, I cannot envision a scenario, but I'm wondering if there is a scenario where in which that would not address that concern, and that would somehow, and the effect would be to exclude those students because of some other scenario that may present itself. I'm just not familiar with the process.
So, I don't know, Carl, you're here. This came up in our court, correct? Because of where you went to law school, that was the whole problem?
Right. Hi, Your Honor. It came up because there were students who met the Connecticut qualifications but did not meet their state's qualifications, so they were unable to participate. And these are kids from Connecticut interning at a Connecticut law firm. So it was creating an undue burden for them. So there were some members of the court who asked that we look into this, and this was our proposal. I agree with Judge Stewart about eliminating 321. I think that was one of the alternate proposals I submitted. So I think that's a good idea.
Okay,
That
thanks,
addresses my
Carl.
concern.
Okay. Does the disciplinary council or anyone want to weigh in on this? No, I don't see that.
Judge
ahead.
Alexander, Christopher Slack. I just thinking about now that eliminating 321, I'm just trying to review 316 to make sure that there wasn't something that would be messed up by that. But I think in a quick review, I don't think it is. So that might be the most direct approach to it. So thank you.
All right. And you said statewide bar is also here, Attorney Del Campo?
Disciplinary counsel is here, Your Honor.
Oh, disciplinary. I'm sorry.
Good afternoon. I'm Brian Staines. Yeah, my office, fortunately, has never had the opportunity to address this issue live. So I would prefer to wait and respond to an actual rule proposal.
All right, that's fine. So is the committee all right with adopting Judge Stewart's proposal right now? And I see a lot of heads going yes. It doesn't mean that it's final, but at least it's something that we can send out. I know it seems as if Dean Nelson is obviously fully supportive of getting the interns before the court, and hopefully our other law schools in the area will respond. So Joe, we might have to resubmit these ideas to those individuals we sent it to. And Judge Pearson, I see your hand.
Yes, Justice Alexander, if you need a motion to adopt Judge Stewart's proposal, I'm more than happy to move that.
Is that something I need, Attorney Del Campo?
Yes, Your Honor. That'd be
All right.
great. Thank you.
Thank you. Thank you, Judge Pearson, for saving me on that one. So we have a motion, and do we have a second?
I'll second.
Thank you. Judge Stewart can't do it all herself. I was just ready to give you the whole everything approved.
She came up with the idea.
All right. So we'll do it the official way, and we'll get this out. And again, do you think this is something that is reachable by March 17th?
Yes, Your Honor, I can get it out. We'll see how many comments you get back, but yes.
Okay. So why don't we put this over to the March 17th agenda and meeting? All right. The next matter is, let's see, 2024-18, and that is a proposal to amend practice book section 236 to require that disciplinary authorities specifically identify in a presentment complaint the specific rules of professional conduct that are being violated, allegedly being violated. Attorney Del Campo, where are we on this proposal?
We, you considered this in November. It was placed on the February agenda. You sought comments from Statewide Bar Council and Office of Chief Disciplinary Counsel, which those are in your package. They oppose this. There was comments sought from the CBA. The CBA has no comments on this, so it's ready for your discussion.
Right. First I'll see, is there anyone here from the public who wishes to comment further? I know this was, I believe, Attorney Sullivan's proposal. I'm not sure if he's on today.
Yeah, I'm here, Your Honor. Thanks.
Okay. Did you want to be heard any further?
I think this is a reasonable proposal. It limits the authority of disciplinary counsel to require, ethics is quasi-criminal, and I think it's important to require specific rules to be cited in a presentment complaint. In the absence of that, I think give too much power to the disciplinary authorities.
Right. Thank you for your comments. Anyone else who wishes to be heard from the public? Were there any comments that we didn't receive that we had sought in this proposal? Besides
believe so.
CBA and disciplinary council. All right.
I don't
Does-
believe so.
Do the committee members wish to discuss this matter further? I don't see that. So is the next thing that we do, again, given my lack of experience, is move to see if we approve any changes or wish to discuss this matter or have this, I guess, further amended.
I believe you would just want to see, Your Honor, if the members would like it to move further.
Move forward, I
public
guess.
hearing, yes.
All right. So I'll ask, is anyone moving to have this go forward in our public hearing? I have no takers, so I would take that as a no. And then what is the result, Attorney Del Campo? Is this just then tabled off? How do you conclude this?
Yes, it's tabled or either off, I guess, because there's been no action taken.
Everybody okay with that? Off, no action taken? I have yeses now. All right. Thank you. All right, our next 2024 matter is on number 19, which is proposal to the practice book sections 13.6, 13.8, 13.9, 13.10, and various discovery forms in light of changes in technology. Attorney Del Campo, if you could again give us a history and where we are as far as our comments, etc.
Yes, Your Honor. This was on the agenda in December. It was put over to February to this meeting. There are comments that have been submitted on behalf of the CTLA. And I believe that Attorney Dowd would probably like to address the committee. There's been some conversation with Judge Bellis. This was sent to Judge Bellis, but the proponents have had a discussion with her, so perhaps Attorney Dowd would like to relate that to us.
Thank you, Attorney Del Campo, and Your Honor. We did have a meeting with Judge Bellis about a month ago where we spent a good bit of time going over the proposal with her, and we welcomed some comments that she had. And we discussed kind of what the next step going forward would be with Judge Bellis. And I think the plan that we have is the CTLA is going to incorporate some revisions and make some changes to the proposal based on the input we received from Judge Bellis, resubmit the proposal to her. And then once we've had a chance to reconvene with her, bring the proposal back to this committee for consideration. So we would ask that in order to allow that process to take place, the matter be tabled for the time being, and hopefully a revised proposal with regard to these standard discovery forms will be submitted in the next few months.
Right. Does the committee have any questions for Attorney Dowd? Or I think that sounds like a reasonable proposal. I see Judge Armada saying yes. So any questions for Attorney Dowd? None. And so, again, my terminology may not be precise, but we'll table it. But I would invite you to resubmit it as soon as you can so that we know we can put it back on our agenda. Thank you.
We'll do that. Thank you for your time.
The next proposal, 2024-20, I did see Attorney Steele come on the screen briefly. And again, this was taken up by our subcommittee on our agenda item 2016, but Attorney Steele, if you had anything you wanted to add further, you're free to do so. Is she still here?
I am, Your Honor.
Okay.
Your Honor, the thrust of my proposal was beyond just counsel. It arises out of a pending case that I don't want to name or go into details, but concerned a witness, and evident confusion on the parts of the court reporter, the court, witnesses, and the parties themselves, how to refer to this witness, how to be consistent in referring to this witness, and created something of a mess in the transcripts and in the record of the case. So I was proposing at least, and I'm not sure the best way to do it, some process by which parties could identify, possibly on the witness list, possibly at a pretrial conference, how various people wish to be identified, and possibly a directive from the judge just to remind their witnesses to attempt to comply. Again, no sanctions, but just as a matter of courtesy, making sure there's a way in which the judge becomes aware of this, not just for counsel, but again, for witnesses, litigants, and so on.
So I think the proposal that we received from the subcommittee, and obviously I would defer to them more, did go to like the filing of the appearance and the parties involved. But I understand your concern. What I'd like to do is, again, we will move this along with that other proposal, and if it hasn't, and I don't think it will at this point encompass the situation you're talking about right now, but I do think at least it's a starting point for us to see if the language for these appearance forms and party forms starts to address the concerns you have, and then we can maybe identify additional areas of practice that may need a similar, again, not for sanction purposes, but more for, the respect that everyone appearing before court should receive. So we'll keep it on the agenda and keep moving it with the 2016, and then we can go beyond that if we need to, okay?
Thank you, Your Honor, and my apologies. I had technical difficulties last month in accessing the meeting.
Oh, no apologies necessary. Thank you for your very thoughtful proposal. All right, so Joe, again, so we keep these together. When we put 2416 over to March, we'll move this one to March as well.
Yes.
All right. We are now at the 2025 002, which is the proposal to repeal practice book section 16 and to add a new rule, section 15.9, that provides for a procedure where the trier of fact, whether by judge or jury, may conduct a view. All right, I'll have Attorney Del Campo introduce this for us.
This is new material, Your Honor, a new submission. It hasn't gone, it's come through, been submitted on behalf of Judge Bellis. You would typically vet it in some fashion, perhaps the CBA.
Does the committee think it should go beyond the CBA? No. All right, we can absolutely get it vetted. Again, we're kind of coming to the end of the committee year. So when do you propose that this should be continued to?
Next month, Your Honor, and we can see what comes in.
All right, we'll put it over to March 17th. The next then proposal on the agenda is 2025-003, which again is to amend Rule 8.4(7) of the Rules of Professional Conduct. Again, it's new material. And I think this was also, this was not Judge Bellis.
This one was
Attorney
proposed,
Atkins?
yes, Your Honor. believe he's here today.
All right. Attorney Atkins, did you want to address the committee in addition, anything further than what your proposal has been submitted to us?
You're muted.
I'm sorry. Thank you, Justice Alexander. Although this item is in the category of first time, I'll point out to the committee that what's being proposed is simply a revision, modification of an existing rule the committee adopted in 2021 to take effect January 1, 2022. As Mr. Del Campo will recall, it was the subject of extensive review by the CBA and its various sections. Comments were solicited from other groups as well. The judges adopted it, and as I say, it took effect on 1/1/22. The reason for my proposal is this. Even prior to the rule taking effect, it was challenged in the United States District Court on First Amendment free expression grounds. By way of background, in 2016, the ABA approved and sent to the states an anti-discrimination, anti-bias rule embodied in Model Rule 8.4G. The Connecticut version, 8.47, is modeled extensively on, but not entirely similar to, the ABA model version. The plaintiffs in the pending lawsuit have mounted a pre-enforcement challenge to the rule. That is, they've not waited for the rule to actually be enforced by way of a disciplinary proceeding. They instead launched a challenge to the rule on its face. Judge Thompson, and I should say that the named defendants, one of them is here today, is Mr. Slack, our statewide bar counsel. The other named defendant is the current chairman of the statewide grievance committee. The defendants, represented by the Office of the State Attorney General, moved to dismiss on two grounds, principally challenging the plaintiff's standing to bring a pre-enforcement challenge to the rule. Judge Thompson granted that motion. The plaintiffs then appealed. The Court of Appeals, in a decision sent down a few months ago, reversed and remanded, finding that the plaintiffs did indeed satisfy the test for standing in these types of free expression pre-enforcement challenges. And so the matter has now been sent back to the district court. I think as of this morning, actually, it's been transferred from Judge Thompson to Judge Omar Williams. Let me just say also that I don't represent any party in that litigation. The firm with which I was affiliated till a month ago, Pullman and Comley, has surfaced on behalf of a non-party witness, but that's my sole connection to the litigation. So this background, I think, is important to point out a few things. Number one, the purpose of my proposal is essentially to address the challenges raised in the pending litigation, which, by the way, is entitled Cerami v. Slack. The Cerami plaintiffs principally challenge the rule as one that risks covering content-based or viewpoint-based speech, particularly in the context of what they say is public advocacy that they intend to engage in. So what the proposal does in a very direct way is clarify in pretty unambiguous terms that that type of public advocacy, no matter how offensive, no matter how disagreeable or objectionable is indeed outside the ambit of the rule's restrictions. The rule also, I think, addresses, some of the other subsidiary challenges the plaintiffs raise in the pending litigation, having to do with potentially vague definitions of the word harassment. My proposal would clarify what harassment is, and more importantly, what it isn't. So that, for example, the language I suggest is that in the definition of the word harassment, we have a section that says quite directly that conduct that a reasonable person would consider as petty slights or trivial inconveniences does not rise to the level of harassment under this rule. Now, I'm not here to suggest that I know that the plaintiffs would be satisfied with this revision. I have not discussed it with either the two named plaintiffs or their counsel. But I would say that I think the likelihood is that if the committee and the judges were to adopt the rule, it would substantially moot the pending case now on remand from the Court of Appeals. Maybe not entirely, but certainly substantially. I want to make one last pitch. No, I'm one last pitch just on process. I would urge that there's some urgency in this, given the pending litigation, and given the fact that this matter, in its original form, the rule was, as I say, subject to pretty extensive review. My suggestion would be that the committee, if it's inclined to refer the proposal outside, consider referring it directly to the CBA committee most directly involved in the rules of professional conduct, and that is the so-called Standing Committee on Professional Ethics, currently chaired by Attorney Stuart Johnson in Hartford. And I'm happy to answer any questions. And thank you for your time.
Thank you, Attorney Atkins. Do any of the committee members have any questions for Attorney Atkins? Again, it's hard on the screens to see hands, but I don't see any. My proposal, if the committee is all right with this, is that I think we're going to need to see some of the information that we had from the 2021 Rules Committee to see what they were considering and the different forms and the different comments that came in, so that at least we have a starting point as to why we adopted this particular rule in 2022. So I'm going to work with Attorney Del Campo and his office to try to get us some further background information. We will take under advisement Attorney Atkins' suggestion of who the CBA referral will be. And then when again, I'm not sure how much material or how long this process was initially, then we'll make a determination as to when it comes back on the agenda. But Judge Pearson, you have I see your hand. Any other further suggestions?
Well, I just wanted to comment briefly on what Attorney Atkins was saying about, the urgency. And I understand, Attorney Atkins, from your perspective, that there's some urgency to this matter. My concern with that is that I was not on the committee when this particular rule was first adopted, and as Justice Alexander just said, it would be nice to know what sorts of discussions, conversations, input went into it. But I assume, based on your description, that there must have been some rather extensive discussions of this rule and a lot of input from a lot of parties. And now we have a situation where the Second Circuit has taken action on that. And it seems to me we'd better measure twice before we cut on this one. I think that while you may feel there's a sense of urgency, we're dealing with some quite delicate issues here of constitutional import. And I don't know that a rush job on this would be the right way to go. That's the only observation I would have.
May I respond ever so briefly? I should have pointed out that the language I've suggested is derived in large part from what New York adopted as its version of Rule 8.4G in 2022. And I know from talking to people in New York, it was very much deliberately designed, their language, to address the concerns raised in the ceramic litigation. So I don't want to leave the impression that this has been rushed. It's really been the subject, the wording I've come up with has been the subject of a lot of deliberation, particularly in New York. And to my knowledge,
let me just ask if I could though, Attorney Atkins, has the New York version of this rule been tested in the federal court system?
the answer is not to my knowledge. That has not been challenged. And for some reason, the versions adopted by various states have not been challenged. Pennsylvania's was challenged. Ultimately, that challenge was dismissed on standing grounds, lack of standing, and Connecticut's version. Those are the only two versions I know that have been subject to First Amendment challenges.
Thank you, Attorney Atkins. Thank you, Judge Pearson. Any other comment? And again, I'll work with Attorney Del Campo to see if we can obtain some more information for this committee's review. All right. Thank you.
I thank the committee for its attention.
Thank you. Our final proposal to amend section 41.9 to repeal the limitations on motions to dismiss was just proposed, I think, in the last few weeks by Attorney Chris DiMatteo. I'm not sure, is he here today, Attorney Del Campo?
I don't see him, Your Honor.
Oh, yeah, I see him.
Oh,
yes.
okay.
And Attorney DiMatteo, did you want to be heard?
Good afternoon, Your Honor. Just very briefly, again, thank you to the committee for considering me, at least at the moment. All I'll say is, again, I probably should have worded it a little better, is really just the proposal to delete toward the end of Rule 41-9, or who has been arrested pursuant to a warrant. And the reason being, I've done criminal defense for really almost all of my career, and there are times when a warrant is an ex parte proceeding. There is no defendants often don't have a response, aren't even involved. Counsel isn't even involved when one is sought and signed. And in the course of representation, during discovery, during investigation, evidence may change or may come into focus where the case should no longer continue. And with the current restriction on the motion to dismiss, there are cases that may sit and wait until trial before that matter is fully litigated. I think that this could not just increase judicial economy by cutting down on some cases that shouldn't be around, but also is, I think it's also greater for clients who someone may be charged with even something weak, something that, again, just a weak case, and the case could drag on for years and years until it is ultimately possibly nollied, or until the client is vindicated with an acquittal. So it's just a proposal for that. I'm not saying that the state's attorneys are often reasonable in situations where you point out flaws or weaknesses in their own cases, but I just respectfully request a more formal method to do that, to bring it to the court's attention.
Right. Does anyone have any questions for Attorney DiMatteo today? Don't see any hands raised. Generally, what we do, and I appreciate you bringing forward this proposal, is we do send it out to be vetted. So I would say we should start with the Chief Administrative Judge for the Criminal Division, which is Judge Gold, and allow him to comment. And Attorney Del Campo, if you think that there are other individuals or organizations that should be contacted, we can do that either simultaneously or after we hear back from Judge Gold.
Okay, Your Honor. Thank you.
I'm not sure this is going to make our March agenda, and we are kind of running to the end of our year because we have a May public hearing for the proposals we have acted on, but it will continue to remain on our agenda and get vetted through the process like the other ones from last year. Okay?
Thank you, Your Honor.
You're very welcome. All right, with that, I think we've gotten through all of our proposals. Is there any other matter that the committee wishes to take up before we adjourn? I don't see anything, so we can move to adjourn.
So moved.
Thank you, Judge Pearson.
Second.
Thank you, Judge Aaron. I recognize your voice even if I can't see you. Anyway, I think we're all set for today. Our next meeting is March 17th. And thank again all the committee members for your hard work and review of these matters. Have a good day, everybody. Bye-bye.
Bye, everyone.
Thank you.